Good day, LML4807 students. Today we will have a brief introductory lecture dealing with lesson 2, which talks to the sources of banking law. Now, a general overview of today's lecture will include that you have to achieve the following outcomes. Firstly, you need to explain what the role of English law is in South African banking law. Then also you will have to apply the sources of South African banking law to a specific scenario. Then we expect you to explain how the terms of a contract as source of law would be relevant to banking law. We also require that you can explain but also apply customary law in a banking law context to a specific scenario. Then, we also require you to explain the position of Indigenous law as a source of banking law, and here we're going to mention the concept of stockvels. Then lastly, we would like you to explain where Islamic law would fit in as a source of South African banking law. Now you're going to ask yourself, why do we require you to study or to know the sources of banking law? In any legal problem that you will be confronted with one day when you are practicing or acting as a legal advisor or in another similar position, you would have to know that if you have a specific problem and you need the answers, you go and find the source. So if you don't know where to find an answer to a specific problem, you will struggle. Hence, the purpose of this lesson. Now, as with law, or most of your law subjects, everything builds on each other. So it's a bit of a building block exercise. Can you still remember when you did an introductory course to law, what the sources were for law in general? You might even have heard that we say or refer to South Africa having a mixed legal system. It basically means that we have many sources. Firstly, we would refer to Roman Dutch law, which is the South African common law, and importantly for banking law, the law of contract would have its origin in Roman Dutch principles. Then in banking law, we have many statutes or legislation regulating the operation of banks. You might have already heard us mentioning that banking, or the banking sector, is a highly regulated sector. Then obviously, we would look to case law to interpret specific provisions of banking law. See why we did the previous lecture on how to read a case. This would specifically be relevant with the National Credit Act, where you might have seen that there has been much legislation going on interpreting the National Credit Act. Then we also look at customary law when applicable. And then, if there's a gap in the law, the courts try and find what we refer to as an equitable and a reconcilable resolution, which would have specific consideration of the basic principles of South African law. This would also be relevant specifically when we look at judgments dealing with the National Credit Act. Now, obviously you know we have a different court structure, and our highest court dealing specifically with non-constitutional matters would obviously be the Supreme Court of Appeal. Do you agree with me when I say that the legal development or the development of law which relates to non-constitutional matters takes place at the level of the Supreme Court of Appeal? The reason for that being obviously that we follow the precedent system. So the highest court would bind the lower courts with the judgment it passes. So you would have seen in some cases where a judgment went from appearing before a single judge in one of the high courts, then an appeal being launched to a full bench of the High Court, for example, and then another appeal being launched to the Supreme Court of Appeal. In some instances, you would even see the matter going further to the Constitutional Court, in the instance where there is a constitutional matter that needs to be decided on. Do you now understand why it is important to understand the sources of law? Because how else are you going to find an answer to a possible solution that you are dealing with? Now, the first type of source we are going to look at for South African banking law would be your English law. Now, obviously, South Africa was governed by the English previously, and we have taken over some of the principles from English law. Banking law is a very good example. One example where one of our acts would be very, very similar, in some instances even containing the exact wording of an English act, would be our Bills of Exchange Act. Not much has changed since 1965, and our Bills of Exchange Act still remain very close or very closely drafted according to the English Bills of Exchange Act. Now remember, I referred in earlier slides to the gaps. So sometimes you have an instance where you don't necessarily find an answer, or there's nothing written either in a statute or in specific case law or a textbook which set out the common law. And in this instance, you can actually go to English law to form a persuasive argument on how a specific gap that's in our legislation should be interpreted. But obviously, as I've mentioned before, the development of the law takes place on a higher level, so obviously this would come through in a Supreme Court of Appeal judgment, interpreting an English law principle that might also apply to South African banking law. Very important, in exams, we usually get students telling us that English law is the common law of South Africa. And that's wrong. Roman Dutch law would be the common law. So when you refer to sources, obviously English law would be a source on its own. Now looking at specific sources, where do I find them? Your first port of call would always be seeing whether there's not a statute or legislation dealing with a specific topic of banking law. We have banking specific statutes, for example, the National Credit Act or the Banks Act, that relates only to banks. However, can you remember in a previous lecture I told you that when we talk about banking law, we talk about a narrow and a wide definition. And if we had to apply a wide definition, then we would actually say that any law, and in our case, in our discussion today, statute, could influence how a bank deals with its clients. Remember the example I told you about when we have a deceased estate and that person had a bank account? So this would be an instance where you might then have to look at other pieces of legislation. One example could also be the Insolvency Act. If you have a client of a bank that has gone insolvent. Now another source would be a term or the terms of a contract. Whenever you enter into an agreement with a bank, you will always sign something. Either it being you opening a credit card or you acquiring a check account, there will always be you agreeing to specific terms that the bank puts forward. These days, it could even be you signing something electronically. Now, these terms of a contract would usually stem from Roman Dutch law, so the basic principles of contract. However, if there's a statute that regulates that specific relationship. So, for example, you opening up a credit card, it would be a credit facility in terms of the National Credit Act. So the contract that you would sign with a bank would thus be influenced by the basic principles of Roman Dutch law, but then you would also see in your contract there would be specific reference to the National Credit Act, and then sections or portions of the National Credit Act would be incorporated into this agreement that you sign with the bank to open up or receive your credit card. Another source that you might not deal with that often would be the law of negotiable instruments. Many of you would have seen in the last few months that most banks have now moved away from using checks. However, the law of negotiable instruments might still find application if you deal with international trade transactions. More specifically, when you come across bills of lading, which is used as a payment method when entering or taking part in an international trade transaction. Another source could also be customary law and trade usage. These concepts are different. Firstly, when I talk about a custom, it would relate to a legal rule derived from custom, and it can be contrary to judicial precedent, so it can be against the case, because in essence it is going to change the law. However, it cannot be contrary to the Boni Mores or a legislative provision. However, a trade usage can never be contrary to any positive law. Then when I talk about trade usage, it relies on the intention of the contracting parties. However, a rule of customary law does not depend on any intention of an individual contracting party. Can you already see that when we talk about trade usage, we might actually then think about some of the codes in the banking industry that would be, or that could qualify as a trade usage. Now, when we talk about trade usage, we need to ask ourselves when a trade usage would be enforceable against a person that had no knowledge of that specific usage. And there's specific requirements that have now come forward, or that's put forward, for such as trade usage to qualify or be enforceable against a person that was not aware of that specific trade usage. In the first instance, it must be universally and uniformly observed within a specific or particular trade. So in the banking sector, for our purposes. Then it must be long established and a well-known usage. The principle must also be reasonable. It must be notorious. So what I mean with this is, a person who is in a specific trade would know about this custom. It must be certain. So it must have a clear and fixed content. It must not conflict with positive law. And it must not conflict with clear contractual provisions. Now, can you see in the slide that I've placed letters in brackets after each sentence? This is just one example of how you could try and make it easier for yourself to memorize a load of facts or items or requirements we list. What you do in this instance, you identify the key word of a specific sentence or principle you need to remember, and then you take the first letter, and then you use the first letters of all of those words, and you either create a word for yourself, or you create a rhyme which would allow you as an individual to remember the elements of, in our example, the requirements for a trade usage to be enforceable against a person with no knowledge. Play around with these letters and see what you can come up with to make it easier for you to remember all of these items. Now remember, in the previous slide I told you that the Code of Banking Practice is an example of trade usage. Now the Code of Banking Practice was prepared by the Banking Association of South Africa in collaboration with its members, which are the banks of South Africa. And it is basically a document that regulates how banks should treat their customers. This document has been redrafted at some times, and most banks would refer to this code on their websites. Now the question you're going to ask yourself then is, if I have this code, it's not legislation, it's not a regulation which was passed in terms of legislation. So what is the legal status of this code? Is it technically enforceable? And to answer this question, you would have to go back and ask yourself, would the Code of Banking Practice qualify as a trade usage? I'm not going to give you the answer here. You have to go and do a bit more reading. But what we've done is we've prescribed a specific article for you, the one written by the TOY, that we require you to go and read and then form your own opinion on whether this Code of Banking Practice would be enforceable. So I want to know from you, what's the legal status of this code? Now the Code of Banking Practice is not the only code that you would come across. For example, you would also find the phase code. Again, the question would be, could this code then qualify as trade usage? Do you see how you have a formal sector like the banking sector regulating itself? You would come across, for example, under the Code of Banking Practice and the phase code, the dispute resolution process. So there is one example of how the banks have also incorporated a dispute resolution process for disputes that their customers might have with banks. These codes will develop, and obviously as banks become more aware of what their duties are, it can be adapted. When you have time and you want to do something practical, go and see if you can find the Code of Banking Practice. Hint, you might go and look at the site of the Banking Association of South Africa, and then take that code and see if your bank actually makes reference to the Code of Banking Practice on their website. Let me know if you find a bank who does not refer to the Code of Banking Practice. Now, Indigenous banking law is obviously a field that's developing in South Africa. And when we get to the following, or one of the subsequent lessons, you will deal with the concept of financial inclusion, where we now find that banks are attempting to incorporate Indigenous banking law as part of their structures. Now, one example of a concept that most of you would be familiar with would be that of stockvels. Stockvels is a very interesting concept where we basically have a credit rotation association where you have a group of people that contributes a fixed amount to a common pool of, I would say, money on a periodic basis. So what do I say? You, Peter, and you, Michelle, would form a credit rotation association, and you agree that every month we put aside 200 Rand. I pay over, or we pay that amount into an account, or we keep it in a kitty under our bed, and we let that money grow. And then, let's say, in 3 months, Peter, you would get everything that's in that bank account, and thereafter, let's say, following 4 months after Peter, you've received your money, I, Michelle, will get the next bundle of money. Me and Peter would sit and we would agree what the rights and obligations are as members of the stockvel. So for example, the money is paid into a bank account. Who must open the bank account? Who pays the fees? Who accounts to the other person? Now, can you already start seeing that in my simple example, and as I say, I don't think the stockvel is usually only 2 people, but can you see in my example that some of the activities could start to resemble that of a formal bank? So let's say a commercial or a mutual bank. So it would be very important that the activities of a stockvel must specifically be excluded from that of a mutual bank and the Banks Act, which is exactly what the South African legislator has done. Now, the piece that we've written in your study guide on stockvels requires more detailed reading by yourself, especially as we will deal with this concept again when we get to the topic of financial inclusion. As we only provide you with some points in our online lectures, we urge you to go and study these provisions specifically dealing with stockvels. And then also keep in mind that in an examination we can actually combine topics. So for example, we could ask a question on stockvels and ask you to explain what the concept means, and then combine it with the topic of financial inclusion. None of the topics should stand separately. So where there is an overlap between topics, it is always a very nice question to ask in an exam. Now, the last source of South African banking law that we're going to refer you to briefly relates to Islamic law. Now, you might have seen, if you open up the website of the bank that you bank with, there would be reference to contracts concluded in line with Sharia law. Most of the banks offer these type of products. Now I want you to go and ponder about a question I'm leaving you with. If you have a conflict between a principle of Islamic law and that, or a separate principle containing in a statute, which of those provisions would actually take preference? You're welcome to provide me with your opinion, either in the chat function on the Teams platform or even on my UNISA. We are curious to see how you interpret this question and how you make an argument in this regard. So please feel free to let me know what answer you come up with. Now, this was a short lecture today, and the purpose we wanted to achieve is to identify those sources of banking law that you need to go and read to find an answer to a problem you have. One day you'll realize it's not about knowing every single principle of law. The person that can find the law is sometimes the better lawyer. And that is why we paid specific emphasis on the sources of law for banking law in today's lecture. All of the best of your studying today, and for the coming week. Again, as with all lectures, we display our contact details on the slide before you, and we invite you to contact us if you have any questions. We just want to keep reminding you, your assignment 1 will be due soon, and it relates to the National Credit Act. Please make sure that you read the specific case and provide us with a good summary of what happened in this specific case. Also remember to follow the guideline that we supplied to you in the previous slide last week on how to read and summarize a case. If you master it once, that is actually a skill that will stay with you for the rest of your life. Enjoy your studies.